let's continue the conversation and our coverage of this alleged corruption at the IDT. Daily Maverick releasing that video that has gone viral showing suspended CEO Tebogo Malaka and the spokesperson Phasha Makgolane allegedly offering a bribe to a journalist to stop the investigations into the entity. Malaka's family trust has since responded, questioning the legality of the recording, describing it as, quote-unquote, a setup. Let's talk now to criminal law expert Ulrich Roux, who joins us to discuss the admissibility of this video. Ulrich, good evening to you. Thank you very much, as always, for your time. Let me put it in a simpler language. Can this video be admitted in court as evidence?
Hi, good evening. Thank you for having me. Yes, it most certainly can. The video evidence, if it should be presented during a criminal trial, will be regarded as real evidence. So real evidence as opposed to testimony by a witness. And it could be presented in court with the necessary foundation being laid by the state in order to do so legally. And what I mean by that is that the state could introduce it and give the background as to how the video came about, why was the video taken, present any affidavits in support of the people who were responsible for the video, as well as obviously of the journalist, and what discussions led to him setting up the recording of this money being handed over to him. In all likelihood, and in my opinion, I do think that the video will be accepted as real evidence should it come the matter proceed to trial. And the only way in which the CEO of the IDT would be able to question the admissibility of the video is if they could question or would question the authenticity of it. So in other words, they would rely on the fact that the video might have been edited, tampered, altered with, and that it is not a true reflection of what actually transpired during the meeting between the journalist and the CEO of the IDT and her spokesperson.
Yeah. What about the argument that if this video would be presented in court as evidence, Ms. Malaka, including Mr. Makgolane, the spokesperson who actually takes out the bag, they would have needed to know that indeed they are being filmed? Would that be an argument, a permissible argument at all?
Not at all. Our new legislation, including the RICO Act and the Films and Publications Act, etc., as well as the Criminal Procedure Act, does not in any way in those acts say that another party should have been aware of the fact that they were being filmed. It makes it clear that if any party who is present or who is a subject in such a video is aware of the video being made, then it is regarded as being legal and lawful. It's the same as the recording of a telephone discussion or a meeting. If you are a party to that meeting or that telephone discussion, then you are fully within your rights to record such a meeting. So that defense, unfortunately, will not succeed, in my view. I've also seen the statement that has been issued by the Malaka Trust, in which they say that the fact that the CEO did not hand over the money, and it was in fact a spokesperson, means that she cannot at all be charged with attempted bribery or corruption. Now, in answer to this, I think the state would say that, she at all times was, of course, very well aware of what was transpiring during that meeting. She, in fact, confirmed that she flew from Johannesburg to Cape Town with her spokesman for the sole purpose of meeting with the journalist on that day. So she, was obviously the employer of the spokesperson when that occurred. And I think that she's going to be very hard pressed to deny, that she was aware of what was happening during that meeting and what the purpose was of her spokesperson, in fact, bringing a large amount of cash worth to that meeting.
Yeah, I'm glad you make mention of the Malaka Family Trust, because as you heard right at the start of our conversation, how we prefaced it is that they're saying that this video was a setup. And so I'm just wondering how easy or difficult would the arguments about presenting this video in court as evidence would be. And let's go back to what Peter Louis Mybeck said as a result of why he decided that he and the editors would actually record this. And he says he got instinct that this was probably going to be the case, that he may possibly be offered a bribe, and therefore they decided that they were going to set up to make sure that they are recording this particular meeting, particularly the second round of the meeting, because the first meeting, as he puts it, takes place with the spokesperson, and therefore the second one would then include the CEO. So the arguments to introduce it as evidence, would those be easy or difficult?
I think it would be easy. I'm actually quite flabbergasted to hear what the Malaka Family Trust is saying in their statement, to be honest with you. They are now taking on the journalist and whoever is behind setting up the filming of this meeting, but they were caught in the middle of committing a crime. So the focus should be on that. It should not be on why the meeting was filmed and who filmed it, and whether the journalist was in fact implicit in this corruption taking place. The journalist makes it clear that they sought legal advice prior to the meeting. They deposed to the necessary affidavits under oath prior to the meeting, in which they set out the reasons why they believe the crime of corruption could be committed, bribery and corruption could be committed during this meeting, and why they are filming the meeting. I don't think that there's any way around that, to be honest with you. It sounds like they have really done their homework in preparing prior to the meeting and filming it, and that this will indeed stand up in court. It is unfortunate to see that the CEO is now trying to wriggle a way out of this, when it is, in my view, and the evidence that I've seen, it is clear that they attempted to bribe this journalist in order not to publish damning information pertaining to a corruption. And I think they should be focusing on that rather than looking for loopholes and trying to wriggle a way out of this.
Just as a final question to you, there is something called the PRECA Act in South Africa, where if you are aware of corruption or a possible attempt to bribe a person, you should go and report that. That would be an interesting question to put to the CEO, wouldn't it be? That here's a person who works for your organization, you seated next to them, and they pull out a bag where they allegedly attempt to bribe a journalist. Have you opened up a case? Would that be expected, or should that be the expectation of the CEO?
Yes, most certainly. PRECA, or more commonly known as the Prevention of Corrupt Activities Act, states quite clearly in Section 34 that any person who has knowledge of or is party to the crime of bribery, corruption, theft, or fraud being committed and does not report it, when there is a duty on them to report, could themselves be charged with contravening that act. The Act does have a condition, though, and it states that it should be in the amount of 100,000 Rand or more. But most certainly, there would be a duty in this instance for her to report that, given that she was a party to this whole transaction that would have taken place. It is clear to me that the reaction of the CEO is that of a person who is, afraid of the truth coming out and the possible squandering of funds, which has been reported on widely and which led to a suspension. And that is why they attempted to bribe this journalist. I don't see them getting out of this one easily, to be honest.
Interesting indeed. Thank you very much. Ulrich Roux, criminal law expert.